I'd like to take this opportunity to publicly thank Michelle Fuerst, the chair for today, for all her work that she's done in putting this program together, and all of our other speakers. They've put a lot of time and effort in, and many of them are from your ranks, and this may be something new to them in terms of public speaking, and we'll ask your indulgence in that regard, although because they're law clerks working in the criminal law area, I'm sure that they're quite used to speaking out in court and so on, so I don't think that'll be a problem, but in any event, I want to thank them all very much on behalf of the Law Society for their participation today. Michelle is no stranger to the practice of criminal law. She's called to the bar in 1981, and she's a partner in her own firm, Gold and Fuerst, here in Toronto, and she restricts her practice to criminal law, both at the trial and appellate level before all courts, including the Supreme Court of Canada. She's very involved in the Canadian Bar Association Criminal Justice Section, being the chair this year. And she's a member of the Law Society's Legal Aid Committee, and she's a director of the Advocate Society since 1989. And a more detailed information is contained in the curriculum vitae about Michelle and all our other speakers. So I'm not going to continue in that regard. I'm now going to pass the podium over to Michelle, who is going to introduce our first speaker and kick off the program for today. Thank you very much for coming. And Michelle?
Thank you, Brenda, and welcome to all of you. We're delighted to have had such a good turnout for this program, which, as Brenda mentioned, is really the first one of its kind that we're aware of in the area of criminal law. There have been other programs, and some of you may have attended them for support staff in other fields, but this is really the first time that there has been an opportunity to try to provide this kind of continuing education forum for the many of you here today who do work in the criminal law field. So we're delighted to see you all out, especially on such a lovely day when I'm sure you could well find many other things to do. I have the pleasure of introducing our first speaker today, who is Katherine Corrick. Cathy was called to the bar in 1981 and for a period of time practiced as a criminal lawyer here in the city of Toronto. She had a very busy and active practice, and some of you, in fact, may have had dealings with her from time to time in that context. Cathy is perhaps unique among us because she had the good common sense to take a year off and spend it in France. Although she tells us that she was studying, she also tells us that she spent her time in an area very close to the Riviera. And I'm sure that it was a wonderful experience, but she's now back hard at it at the bar admission course. She is now a member of the full-time faculty there. As you know, or may know, that course has undergone a great degree of change in recent years, and Cathy is one of the several full-time faculty who have been very active in putting together a very new and innovative kind of program for our bar admission course students. Cathy has been primarily responsible there for the design and implementation of the criminal law segment of the program. So given her practical experience as well as her teaching background, she's very well qualified, I think, to speak to you today on the topic of the criminal courts and an overview of our criminal procedure and criminal justice system. So without further ado, Cathy Corrick.
Thank you, Michelle. I've been given a rather difficult task this morning because I've been asked to do in 45 minutes what we take 6 days to do in the bar admission course, and that is give you an overview of basic criminal procedure. I'm sure that at one time or another, some of you or most of you have done something at the request of a lawyer. And although you may have done it well and known exactly what you were doing, you might have had no real idea of why you were doing what you were doing or how it fit into the larger scheme of the criminal trial process. Hopefully, if I do my job right this morning, your jobs will be more interesting and will be a little easier because you'll have a better idea of the big picture of how the criminal courts in Ontario work. And I'm going to focus today just on the trial process, because later on this afternoon, there will be a panel that's going to discuss the appellate procedures in the province. So today, this morning, it's just the trial process. What I propose to do is highlight some of the fundamentals of criminal procedure without which you can't really understand the path that a criminal charge takes through the courts. I obviously can't do that in a great amount of detail in 45 minutes, but there's a paper in your materials that I wrote that gives you somewhat more detail, and I suggest that if you have questions in that regard, you refer to the paper. So after I highlight some of the fundamentals, I then propose to show you the two most important documents in criminal procedure, and those are the information and the indictment. And I can show you some of the different kinds of information and details you can get off of those documents that will make your job easier. And finally, and hopefully if we have time, I propose to, with the use of a hypothetical case, take you through the court system with the use of the chart that's on the back page of my paper in your materials, and which will be on the overhead. So first of all, to begin with, there are two courts in the province of Ontario that deal with the trial matters of criminal charges. And those are the Ontario Court of Justice Provincial Division and the Ontario Court of Justice General Division. And for those of you who have been around for a while, that used to be the Provincial Court and the District Court, or before that even the County Court, if you've been around as long as I have. Every accused person begins in the Provincial Division. No matter what that accused is charged with, the first court appearance is always made in the Provincial Division. To determine what happens to the charge after that, you must first determine what kind of offense the accused is charged with. And the Criminal Code creates three kinds of offenses. And they are summary conviction offenses, indictable offenses, and hybrid offenses. And to find out what kind of offense your client is charged with, you have to look in the Criminal Code. The section of the Criminal Code that creates the offense also will tell you whether it's summary conviction, hybrid, or indictable. So for example, section 740 of the Criminal Code creates the offense of breach of probation. And it says, an accused who is bound by a probation order and who willfully fails or refuses to comply with that order is guilty of an offense punishable on summary conviction. So you know by reading that that breach of probation is a summary conviction offense. The robbery section in the Criminal Code, section 344, says everyone who commits robbery is guilty of an indictable offense and liable to imprisonment for life. So you know that robbery is an indictable offense by reading that section. And finally, section 271 of the Criminal Code says everyone who commits a sexual assault is guilty of A, an indictable offense and liable to imprisonment for a term not exceeding 10 years, or B, an offense punishable on summary conviction. And that's what's known as a hybrid offense. It can be proceeded with either way, by indictment or by summary conviction. And we're going to talk about that a little bit later. Now, summary conviction offenses are the least serious offenses in the Criminal Code. There aren't really very many left. The Parliament makes almost everything now either indictable or hybrid. But some examples are joyriding, cause a disturbance, communicate for the purpose of prostitution, and breach of probation. All summary conviction trials are heard in the Provincial Division by provincial court judges. They're never heard in the General Division. Indictable offenses are the most serious offenses in the Criminal Code. And they include things like murder, break and enter, robbery. And to complicate matters, there are three subcategories, really, of indictable offenses. The first I'm going to call section 469 offenses. These are the most serious offenses in the Criminal Code. and they're listed in section 469. These offenses must be tried in the general division. They can never be tried in the provincial division. And subject to some small exceptions, they're also tried by juries. These offenses include murder, which is obviously the most common, but other interesting things like treason and piracy, alarming Her Majesty, things that don't arise too often. The second subcategory of indictable offenses are called, or what I call, Section 533 offenses. These are offenses that are listed in Section 533, and these offenses must be tried in the provincial division. And these include things like keeping a common gaming or a common bawdy house, theft under $1,000 if the Crown elects to proceed by way of indictment. It doesn't matter that it's an indictable offense. It still must be tried in the provincial division. And they're known as absolute jurisdiction offenses because the provincial court judge has absolute jurisdiction over them. The final subcategory of indictable offenses include all the other indictable offenses in the criminal code. And an accused charged with one of those offenses has the right to choose or elect the way the trial will be held. And the accused has three choices. The accused can elect to be tried in the provincial court by a provincial court judge in the provincial division, or the accused can elect to be tried in the general division by a judge alone, or the accused can elect to be tried in the general division by a judge and a jury. The choice is the accused's. There are never any jury trials in the provincial division. There are only juries in the general division. If you're having your trial in provincial division, it will be before a provincial court judge alone. The third category of offense is called a hybrid offense. And these are conceptually the more difficult offenses. The Crown Attorney gets to choose whether the offense will be an indictable offense or a summary conviction offense. And there are a number of considerations that the Crown Attorney will take into account in determining whether to go by indictment or by summary conviction. The accused's criminal record, the seriousness of the charge. There are many things. If the Crown elects to proceed by summary conviction, the trial will occur in the provincial division, just like a regular summary conviction offense. If the Crown elects to proceed by indictment, and the offense is not one within the absolute jurisdiction of the provincial court judge, the accused can choose where the trial will be held. Provincial court judge, general division with a jury, or general division without a jury. There are a lot of hybrid offenses in the criminal code. Theft under, impaired driving, sexual assault. So you can assume probably that if your client is charged with the first offense of impaired driving, and it's sort of the run-of-the-mill impaired driving where there aren't any extenuating or aggravating circumstances, it's a pretty safe bet that the Crown Attorney is going to proceed by way of summary conviction. On the other hand, if this is your client's 10th impaired driving or 5th impaired driving, it might be a safe bet that the Crown Attorney might proceed by way of indictment. The way the Crown Attorney proceeds can have grave consequences for the accused if convicted. And I use the example of sexual assault only because it provides the best contrast. If an accused charged with sexual assault is convicted and the Crown has elected to proceed by way of summary conviction, the maximum penalty the accused faces is 6 months in prison or a $2,000 fine or both. If the accused, on the other hand, the same accused, is convicted and the Crown proceeded by way of indictment, the maximum punishment that accused faces is 10 years in prison. So there are grave consequences for the accused, and often lawyers will spend a great deal of time in the bargaining and the pretrial discussions with the Crown, trying to convince the Crown to proceed by way of summary conviction. And I raise this with you because when you're doing legal aid accounts, on the form, I believe there's a place for you to check, how did the Crown elect to proceed? And lawyers are paid more, generally, when the Crown elects to proceed by way of indictment. The final point that I want to talk about in terms of election is preliminary inquiries. Now, preliminary inquiries are only conducted in indictable matters where the trial will be held in the general division. They're conducted in the provincial division by a provincial court judge. So, an accused charged with an offense like murder, which must be tried in the general division, or an offense like robbery, where the accused has elected to be tried by a judge and jury or a judge alone in general division, will have a preliminary inquiry before the trial, and that preliminary inquiry will happen in the provincial division. And the purpose of the preliminary inquiry is to determine if there's enough evidence to make the accused have a trial. I'm sure everyone remembers the Susan Nellis murder case. The nurse at Children's who was charged with murdering a number of babies. Following the preliminary inquiry into those charges, she was discharged. The provincial court judge found that there was not sufficient evidence to make her have her trial. It's a very low test. It's really virtually no evidence. If there's even a little bit, usually, the accused will be committed for trial and ordered to stand trial in the general division. It's grown up because there's never been formal disclosure procedures in the criminal process the way there is in the civil courts with pretrials and examinations for discovery. Over time, it's become usual for defense counsel to use the preliminary inquiry to see what kind of evidence the Crown has. Because really what you get before trial, the lawyer, is just a bunch of statements. And they're not usually verbatim statements. They're statements that a police officer makes up. So what you're reading is what the police officer says the witness is going to say. And police officers sometimes engage in wishful thinking. And what's on the piece of paper in front of you is more what the police officer hopes the witness is going to say. So at the preliminary inquiry, you get a chance, the lawyer gets a chance to see the witness in flesh and blood and see what the witness has got to say and how the witness reacts in the witness box as well, both under examination in chief and under cross-examination. And it helps the lawyer to prepare for the trial and the tactics that the lawyer will take at the trial. Once the accused finishes the preliminary inquiry, either the accused will be discharged, and hopefully for the accused, that will be the end of the matter. Occasionally, the Crown Attorney does have some power to make the case go on, but it doesn't happen that often. If the accused is not discharged, and the provincial court judge thinks that there is sufficient evidence to make the accused have the trial, the provincial court judge will order the accused to appear in the general division in perhaps 1 month's time. And then the process of setting a date, having a pretrial, etc., will start in the general division. Now, all proceedings in the provincial division are conducted on the basis of a piece of paper known as the information. And this is a formal document that a police officer, usually private citizens can do it as well, swears before a justice of the peace. So a police officer will typically go before a justice of the peace and swear, take an oath, that that police officer believes that Joe Blow has committed robbery. And an information will be drawn up and it will be placed before the court. And each time the accused appears in court, the clerk of the court will record what happens on that information. And I have one on an overhead. Now, I apologize for those of you who aren't from Toronto, but it was convenient for me to get things from Toronto. So this is an information that charges Mr. NG with manslaughter. And you can see that Michael Hamill is the police officer who swore the information. And in this case, he also happens to be the investigating officer from the homicide squad. So Michael Hamill would have gone to the Justice of the Peace and sworn that NG on the 8th day of September 1990 killed RH. And you can see here, right here, that it was sworn before the Justice of the Peace on October the 23rd. So probably NG was arrested sometime shortly before that, not immediately after the manslaughter on the 8th of September, because it took until October the 23rd for the police officer to go and lay the information. So the Justice of the Peace must sign the information. If the information is before the court without a signature of the Justice of the Peace, it's really tantamount to not being before the court, and the court will have no jurisdiction to deal with the accused. And Michael Hamill as well has signed the information. Now, the information contains all of the relevant details about what happened in the provincial division. And there's all these boxes down here that the clerk of the court checks when something happens. So for example, in this case, the accused elected to be tried by a judge and a jury. And the accused, after preliminary inquiry, was ordered to stand trial. And you can see on January the 21st, 1991, Judge Carter ordered the accused to stand trial and to appear at 361 University, which is the general division, on February the 15th, 1991 at 9:30 a.m. And over here, there are a number of orders that Judge Carter made throughout the preliminary hearing. He ordered that no one publish the nature of the evidence that was heard, which is very common at a preliminary inquiry, that a lawyer always asks for an order banning publication, because you don't want the evidence that's heard at a preliminary inquiry all over the Toronto Sun so that every potential juror reads it. And also an order excluding witnesses except Detective Hamill, which is another very common order that lawyers ask for during any matter, during a preliminary inquiry or a trial, because you don't want every witness to hear what the preceding witness has to say. Now, this is just the front page of the information. There's another page, the back page. And it's on this page that you'll get information for things like ordering transcripts, what day your client appeared in court. And at the top here, that's the day of the court appearance. This is the day that the accused has been remanded to. And this is the court that the accused has been remanded to. And this is the purpose that the accused is remanded to that court. So on October the 25th, Mr. NG appeared and was remanded until October the 26th in 301 court at 9 a.m. for a show cause hearing. And a show cause hearing is just another name for a bail hearing. And then you can see on October the 26th, unfortunately, he had his bail hearing and he was detained in custody. The judge ordered a detention order. So let's say that the lawyer that you work for says, I want to do a bail review for Mr. NG. I want to try to get him out before his trial. Get me, please, the transcript of the original bail hearing, which has to be filed for every bail review. So what you can do is, once you get the information, you can see that the bail hearing happened on October the 26th. Down here on October the 26th, you can see that the clerk was Solomon, the reporter was Spencer, the Crown was Tate, The lawyer was Fishbane, and the justice of the peace was somebody with the initials LD. So you know that you have to contact Marlene Spencer to get the transcript of that bail hearing for your bail review. And often the clerk will put little notes to help with court scheduling. So for example, they've said all day, that this matter will take the entire day, which tells the clerk don't set anything else on January the 21st, 1991 in 303 court, because this case is going to be in there and it's going to take up the court space all day. Does anybody have any questions while this is on the overhead about the information? Once the matter is concluded in provincial division, the next stop for the accused is the general division. And the charge is no longer contained on an information. It's now contained on a document called the indictment. And don't get the indictment, which is a piece of paper, confused with proceedings by indictment. They're just the same word, but they're unrelated. And an indictment is not as formal a piece of paper in the sense that it's not sworn to. It's a piece of paper that's prepared by the staff in the Crown Attorney's office on the basis of the information which gets sent from the provincial division to the general division. And this is just typed up by someone in the Crown Attorney's office and put before the court. And again, it's before the court for every court appearance that the accused makes. And the clerk notes on the back of the indictment everything that happens in court that day. And the judge signs it, or the justice signs it. I should add that in addition to the clerk noting things that happen in court, there's obviously the court reporter who's taking down verbatim everything that everyone is saying. So, Mr. NG was committed for trial, and this is the indictment that was typed up. And Stephen Leggett is the Crown Attorney up at North York, and this was a North York case, and he signs the indictment, but it's not sworn to, as I indicated. And this little amendment, at the opening of the trial, the Crown sought to amend this indictment because there was an error, and in fact, the manslaughter had not occurred on the 8th of September, but had occurred on the 13th. So at the opening of the trial, the Crown asked for that amendment, and it was granted. And you can see that Mr. Justice Ewischuk, who was the trial justice, signed the amendment. Now, the back of the indictment doesn't have as much information as the back of the information, but it still tells you quite a bit of what went on. On February 15th, the accused made his first court appearance. He was adjourned until February the 19th, 91, to be spoken to. And the judge is Mr. Justice Whaley. And this little notation here, PT, means that a pretrial has been ordered on the 19th of February at 9 a.m. The next notation is Mr. Justice Humphreys, indicating that in fact a pretrial has been held. The accused then appeared February 19th, and Madam Justice Corbett said that the trial shall be April the 2nd, 1991, and the Crown is to confirm the leave dates within 1 week, adjourned on consent. And leave dates are the annual holidays for the witnesses. So police officers take their annual holidays and they have to decide what holidays they want far in advance, and it's usually noted on the Crown's confidential instructions so that trials aren't set when the investigating officer is on vacation. Then, April the 2nd, 91, the trial began. And you can see from the very first line that this accused re-elected to be tried by a judge alone, non-jury. You saw in the information how the original election was judge and jury, but in certain circumstances the accused has the right to re-elect. Usually it's because you like the judge you're in front of. So you don't need a jury. If the judge that you're in front of has what you think to be a good sense of reasonable doubt, then you might not want to have the jury. So this accused, I don't know why in this case they re-elected, but they re-elected to be tried by a judge alone. The plea, not guilty. The indictment was amended. Crown case begins, trial to continue daily until completion. And then it sets out the 2 adjournment dates, verdict guilty, and the sentence, the date that the accused was to be sentenced. And you can see that each time something happens, the justice before whom it happens signs the indictment. Now, the accused was put over until April the 8th, 91 to be sentenced, and over here you can see that that's the sentence: imprisonment for a term of 1 year and a prohibition order, section 100, for 5 years. That's an order not allowing the accused to own weapons. Once this happens in court, the indictment is taken back to the registrar's office at the general division, and the staff there prepare a warrant. And the warrant is sent to the jail along with the accused. And it's on the basis of that warrant that the jail has authority to hold the accused. And occasionally it happens that what's written on the warrant and what was written on the indictment are different. And you'll get a frantic call from your client saying, they think I'm here for 2 years, and the judge said only 1 year, or something like that. And so this will be the thing that determines it. All right? And all the indictments are kept in the registrar's office of the general division, which is on the 2nd floor, room 241 at 361 University. And similarly, all the informations are kept in the clerk's office in the provincial division. Yes? The question is, when you make a re-election, is it done by way of motion or is it just done verbally? It can be done both ways. You don't do it ever by motion, but you must give notice. In Toronto, the practice has developed that often you can just stand up and tell the Crown and tell the judge that you wish to re-elect, and you do it on the spot. But you have to have the Crown's consent if you're outside of the appropriate time limitations. Otherwise, you have to give your notice of re-election in writing. There was attached to this indictment a re-election form. I just didn't produce it for you. And what will happen is, this wasn't done in advance, it just happened on the trial date. The accused's lawyer had the consent of the Crown and stood up and re-elected, and the Crown and the defense counsel signed the re-election form, and that's all that happened. In other jurisdictions, such as Peel, for example, the Crowns will not, for the most part, consent to re-elections on the trial date, and you have to give notice in writing. Yes? The question is, what is the appropriate time limitation for re-election? Can I answer that for you afterwards? Because it depends on what the original election was, how you wish to re-elect, if you originally elected judge alone and now wish judge and jury, or if you originally elected judge and jury and want judge alone, or if you're going from provincial court judge to judge and jury. I can answer that, but I have to look it up in the code.
So there's no real set pattern established yet, is that it?
Oh yes, there is. The criminal code prescribes a time limitation. I don't know it off the top of my head. It's not long. It's perhaps within 15 days after committal for trial. So unfortunately, you don't know what judge is going to hear your trial. So you lose the advantage of knowing whether you have a good judge or not. You have to be a bit of a gambler. I meant to point out to you one further thing, I'm sorry, on the back of the information. When you're doing a bail review and you're filing your documents in the Crown's office, most of the time they want to know, what division is this case from? Who is the officer in charge? And that's because if the matter is still in the provincial division, the Crown Attorney's office at the general division doesn't have any confidential instructions there. They're kept at the police station until the matter goes to the general division. So when you file bail review documents, they want to know what police division or what police officer is in charge of the investigation so that they can order their confidential instructions. So the Crown Attorney who's arguing the bail review knows what the case is about. And on the back of the information, you can always find out who the investigating officer is. So it's here. I'm sorry that it's sideways, but that's how it appears on the information. You can see that it's Officer Hamill, and the division is homicide. Let me turn that up for you. So, I mean, in this case, it's homicide, but it may say, you know, it could be Hamill 31 CIB, which is Criminal Investigation Bureau, or 31 MCU, which is the Major Crime Unit. But you can always get that information off of this document.
Is there anywhere that you can get that? I've gotten information lots of times when the officer's not on the information at all. There's no division or anything. Is there any way to get that?
The question is there any way to get the name of the officer or the division if it's not noted on the information? The only way would be to call the Crown. No. Well, if the lawyer has received the synopsis of the charge from the Crown on the first appearance, let's say, that will have the name of the officer and the division. And you know, in Toronto, the courts are divided up by division. So that, for example, East Mall only takes 21, 22, and 23 division cases. So you can sort of narrow it a bit with that. The final thing that I wanted to do was to follow, or at least try to follow, two hypothetical cases through this chart so that you can see how it works. And the chart is in your materials actually at page, I think, A8. Okay. So let's take, for example, the accused who's charged with robbery. We know that robbery is well, let's take, for example, never mind that, Mr. NG, are accused from the information in the indictment. He was charged with manslaughter. So what happened was, manslaughter is an indictable offense. What happened was Mr. NG started out in the provincial division for a bail hearing. And as I said, all accused start out there. And all accused, except those charged with Section 469 offenses, which are murder, accessory after the fact to murder, have their bail hearings in provincial division. So Mr. NG had his bail hearing in provincial division, and he wasn't charged with an offense in 469 because manslaughter isn't murder, it's different. He wasn't charged with an offense listed in Section 553. So Mr. NG had an election, and he elected to be tried by a judge and jury. But you can see across there that those were the three choices: provincial court judge, judge alone, and judge and jury. Once that election was made, the next stop for Mr. NG was the preliminary inquiry in provincial division. Following that, the judge and jury trial in general division. If Mr. NG had elected to be tried by a provincial court judge, it would have stopped right there. The trial would have been in provincial division, no preliminary inquiry because they're only held when the trial is going to be in general division. But as you're going to learn this afternoon, I'm sure you probably already know, that all indictable appeals go to the Court of Appeal for Ontario. It doesn't matter where the trial is heard. Whether it's heard in provincial division or in general division, if it's an indictable matter, it still goes to the Court of Appeal for Ontario. So let's take another accused, this time charged with sexual assault, which is a hybrid offense. And we can assume that the Crown has elected to proceed by way of summary conviction. So then the sexual assault just becomes a plain summary conviction offense like the others, just like joyriding and cause of disturbance. And the trial is held in the provincial division. And the appeal would be in the general division because that's where all summary conviction appeals are heard. If, on the other hand, the Crown elected to proceed by way of indictment for the same accused, we would just start the same process that Mr. NG went through. Sexual assault is not listed in 469, it's not listed in 553, so the accused would have an election. And depending on how the accused elected, he would either have a preliminary inquiry or a trial in provincial division. And if he had a preliminary inquiry, he would then have his trial in general division. I hope that makes things a little clearer. I think that the chart will help to visualize sort of the basic flow of a criminal charge. All right. The question is, do you have to make your election prior to having a preliminary inquiry? In Toronto, the practice is you appear for your preliminary inquiry, but no one knows it's going to be a preliminary inquiry until the accused is arraigned, which means the charge is read to the accused, and the accused is put to the election. In other centers, such as Peel, for example, the accused must make the election on one of the very first court appearances, which is very difficult because often there isn't disclosure ready. The lawyer doesn't have any idea really how strong the case is against the client, but nevertheless, the accused is called upon to determine how they want to be tried. The question was, do I mean on a set date? Yes, I mean on a set date.
So what do you tell the client to elect when he phones the office and he says that they want me to elect?
The question is, so what do you tell a client? Okay, what do you tell a client who calls you? Because often I've seen it happen. The poor client is in court with a set date letter. And the set date letter doesn't tell the judge how to elect. You always, it was always my advice to my secretary, you tell the client to elect judge and jury, because it is easier to elect down than it is to elect up. I mean, judge and jury trials take a long time. Lists are busy. Crowns want to get the stuff through. They're far more likely to consent to re-electing to a judge alone trial than they're ever going to consent from a judge alone to a judge and jury.
But it is done that way? Like
It can be. It can be, yeah. But I think you're pretty safe if you always tell the client, judge and jury. Okay. The question is, how do pretrials fit into this? In the provincial division, I'm not sure. I don't think it's really formalized. It's certainly not formalized in the criminal code. But in some jurisdictions, there are just rules that a judge won't set a date until there's been a pretrial held, because realistically, no one can estimate how much time a trial is going to take until they know what the case is about. But the criminal code does prescribe pretrials in the general division for every case that's to be heard by a jury. And you saw on the back of the indictment for Mr. NG that a pretrial was held before Mr. Justice Humphrey. And then the trial date was set. What is the purpose of a pretrial? Sometimes that's a good question. But the purpose of the pretrial is supposed to be to narrow the issues. At a pretrial in the general division, the justice who is hearing it, it's quite informal. It's done in the justices' chambers with the defense counsel and the Crown counsel. And the judge will want to know, for example, does defense have disclosure? Is there any chance of a guilty plea, which is always a big question? Is there any chance that you're going to consent to anything? Are you going to raise any charter issues? Will there be a voir dire on the issue of whether or not the accused's statement was voluntary? It's supposed to narrow the issues and assist in court scheduling so that the justice who hears the pretrial has some idea of how long this trial is likely to take. In other areas, for example in Peel, if you have a pretrial and your client wishes to plead guilty, you can, depending on who the judge is, discuss the sentence that you may have been discussing with the Crown Attorney and get some feel for how the judge is feeling about that sentence. And one of the nice practices in Peel is that you can then go into court before that justice and your client will plead guilty. So that you sort of have an upper edge in Peel in that one case.
When you refer to pretrials, you're always saying in general division. Why are courts like Scarborough now making their clients call and say, we won't set a date unless you get a pretrial date first?
Okay. Well, the question is, why am I always referring to general division when I'm talking about pretrials, when in some provincial divisions they say, we won't set a date without a pretrial? The pretrials in general division are prescribed by the criminal code. You must have one if it's a jury case. The pretrials in provincial division are usually just the chief judge of the provincial division's idea to help with scheduling. Okay, the question was, will that be in more serious cases? And I'm not sure if they're asking it for every case, but I can't imagine that there is manpower or person power to conduct a pretrial for every theft under and impaired driving. Am I correct in assuming that the justice who hears the pretrial does not hear the trial? That's correct. They want to encourage everyone to be open, and perhaps they'll learn information that they ought not to have if they were hearing the trial. That's the reason for it. Go ahead. Okay. A brief scenario of where a voir dire would take place. The most common one is when the accused gives a statement to the police. The law says that before that statement can go into evidence, the judge must determine whether or not it was voluntarily given. In a jury trial, you obviously don't want to have that little hearing. A voir dire is like a little trial within a bigger trial. So if there's a jury, voir dires always happen in the absence of the jury. The judge will ask the jury to leave the room. There will be sort of a little trial about whether or not what the accused said to the police was said voluntarily. Then the jury will come back into the room, and if the accused has been admitted, or pardon me, if the statement has been admitted as voluntary, all the same evidence will again be presented, but this time in front of the jury. And if it's a judge alone case, it's basically the same thing, only obviously the judge doesn't excuse him or herself, but it's just a little trial within a trial, and the judge must make a decision about whether or not the accused statement was voluntary. Well, the test basically, voluntary, of the accused's own free will, that there were no promises or threats held out to the accused in order to make the accused make the statement. I didn't know we're having an evidence course this morning, sorry. Are there any other questions? Were there any question forms? Okay. Well, thank you for listening.
The next portion of the program we've called Organizing a Criminal Law Practice, and as I'm sure you can appreciate, it's a very broad topic. I'm happy to tell you that we have today on the panel two of your peers who have a great deal of knowledge and experience in this area, and I think you'll find that one of the most interesting things about them is that they work in very different kinds of offices and very different kinds of practices. So we hope that between the two of them, you will get a good overview of different ways of handling organizational problems that crop up from time to time. On my right is Mary Theresa Connolly. Mary Theresa works in the law office of David Gorell, who many of you know is a very experienced criminal practitioner in this city. She's been with him, she tells me, since 1981,
Yes.
which is a very long time. And obviously, she has a great deal of responsibility within that office. On my left is Lisa O'Brien. Lisa's with the firm of Greenspan Humphrey. She tells me that her office is largely computerized, and we're hoping that she can give you some tips for those of you who are interested in exploring that area. As you know, criminal lawyers spend most of their time outside of their offices. They're usually in court. So, Lisa, my first question to you is, how important is it for the support staff to know what the lawyer is doing and where he or she is during those daytime hours when you're alone in the office?
Just from my own experience, I found just from working within other offices and relating with other secretaries, I found that a lot of lawyers don't make it their practice to tell the support staff where they're going to be at any given time during the day. And I'm sure most of you know that this can be a very frustrating experience. So, you know, when the need arises to contact the lawyer to ask a question or tackle some type of problem that has arisen during the day, obviously if you know what court the lawyer is going to be at and how to contact them, it makes it much easier. The lawyer that I work with, we make it a practice, especially if she's going to be on a lengthy matter, to contact each other at specified points throughout the day. That way I know if one of her client calls and poses some kind of problem or something comes up that I'm not capable of tackling, or any of the other secretaries, since most of the lawyers are not there throughout the day, they run a courtroom practice, I can tell the person and appease them and tell them, you know, I'm going to be speaking with her at some point in time, and I can let them know I'm going to be able to field that question to her and get back to them, and so I don't look like an idiot on the phone.
Mary Teresa, if you happen to work for a lawyer who isn't as well trained as the lawyer Lisa works for and doesn't remember to call in during the day, what can you do to try to find out and try to keep track of where the lawyer is on any given day?
Well, I find in our office it's necessary to keep a duplicate copy of the lawyer's diary so that I know exactly which courtroom at least he's going to be in. And the lawyer, I'm fortunate that the lawyer I work for phones in, but I try to find out from the other lawyer that I work for sometimes where he's going to be in the morning. He can tell me generally which court he's going to be in first, and then I can advise the clients or whomever is calling where he's going to be. But it is very important to keep a diary that is an exact duplicate of the lawyer's, to keep it up every day, to impress upon the clients when you send them out with letters that they must call you by the end of the day or first thing the next morning to tell you what dates they have set so that there's no duplication there. And if the clients do not call you, I end up calling the court myself the next morning, and they say, well, why are you calling? Doesn't your client let you know? They don't realize they're criminals, and they don't even have a phone. But that's what I find is most important, is to keep the diary up to date as quickly as possible.
And Mary Teresa, what kind of information do you put in that diary?
I put in his appointments, every courtroom that he has to be in and the time that he has to be there, the client's name, and in the afternoon I know when he wishes to schedule his appointments to see clients for interviews, so I have to keep that in the appointment book. I also have to keep his personal appointments so that I'm not scheduling a client at 4:30 one afternoon when he has a dentist appointment, because that can upset the client when they find out that I have to change their appointment.
Lisa, can a computer be of any assistance in trying to keep track of the lawyers in the firm?
Well, the firm that I work for has 3 lawyers, and I find that we all use a computerized court list, and this makes it really easy because we have lots of clients and it's easy to make revisions and everything is always kind of neat and tidy and organized. I know some offices we don't make it a practice because we only have 3 lawyers, but some offices even go so far as to integrate all the lawyers' court lists, and this can be really useful if you have a couple of junior lawyers who will be taking the court list to provincial court, and they're at provincial court setting a couple of dates or something like that, or and then you know where everybody's going to be, and if the judge wants to set a date, or there are co-accused, and a date has to be set at a certain point in time, and it doesn't meet with the lawyer you're working with, their schedule, then at least you know somebody else from the office can be there on any point in time, and you can work around it that way.
Well, aside from knowing where the lawyers in the firm are, obviously the other important thing for support staff to know about is the clients in the firm. So Mary Teresa, let me ask you, to what extent do you feel that support staff should become familiar with the actual client files and the status of the client's cases?
Well, I think that the support staff should know pretty well exactly what's going on. When a client is arrested at our office, I find out immediately from the lawyer what the charges are that the client has been charged with, his next court date, the courtroom number that he's going to be in, and then I want to know the client's date of birth. I want to know his middle name in case I need that information to give to a police officer if I want to move the body somewhere. I need to know by looking at the correspondence when I open it in the morning if medical reports are ready, if the disclosure is ready, if the Crown phones to say the disclosure is ready, or if I have to go and pick that up. I need to know when all of these things are available.
Lisa, do you do things differently in your firm?
Well, generally, when we get a new file, I just stick my nose right in there and I make sure I go over all the correspondence. So I try to be as familiar with the file as possible, because you know somebody's going to be calling, and you know if you have a practice where the lawyer's not there, you should be able to handle things as well and know generally what's going on. I also, just for my own personal use, keep what I call an active client list. And what I do is just on the computer, I list the surname, and I generally put, if it's a trial, when the next court appearance is. If it's an appeal, I'll just put that it's an appeal, because I'll talk about later how I keep a separate appeal checklist. And then I just a column just for miscellaneous notes, anything I need to know. Does disclosure have to be ordered? Anything else that may be happening with that matter? Are we doing a bail review at a certain point? Then at any given time, if a client calls and wants to know something, I don't have to flip through a court list to find out what's going on. I can just at a glance know what's going on with their file, and I can let them know, because although I generally have a pretty good memory, you don't always remember everything, and this is kind of something I use like a backup.
So Lisa, you've talked about keeping an active client list in terms of being able to use the computer to make your life easier, but I assume that people who work in offices that aren't yet computerized could do the same type of thing?
I'm sure you know you can do it manually. I just tend to do it on the computer just for ease of revision and just to keep it neat and orderly because these types of things, dates are always being changed and things are always being changed with clients on an ongoing basis, and it just can get kind of messy if you're doing it manually. But I'm sure you could do it on the typewriter, or even just keep some type of book that you could keep all those types of notes in, just to be at quick reference.
I can tell you as a practitioner that much of a lawyer's time in the office seems to be taken up by things that we might consider to be somewhat routine, and I'm referring to things like returning telephone calls and answering correspondence. Lisa, how can a member of the support staff help make a lawyer's life easier by assisting with those kinds of tasks?
As I say, I really get into the file, and my lawyer that I work for, she gives me an awful lot of responsibility. And I like to think that I do make her life a little bit easier. When a phone call comes in and a message is put on her desk, I see if it's something I can tackle, or at least call the person to get a more detailed message, so that they're just not coming in going, well, what is this? And then they have to go through, I mean, they're going to have to go through that process anyway, and I tend to like to get that out of the way. I also, when correspondence comes in, I read it, see if it's something I can handle. I do a lot of what I call busy work, just sending out cover letters for checks that have to be sent out for transcripts, and then ordering transcripts or that type of thing. And I draft a lot of letters, and then she kind of jokes sometimes, and she says she's like Colonel Blake in MASH, and I'm like Radar, just sticking things in front of her saying sign on the line. But I tend to do a lot of the correspondence, and she just signs it.
I think one of the most comforting things for a client who approaches a criminal law firm is to get a sense from the support staff that he or she is on top of things, is aware, for example, of where the lawyer is at a given time, or has the information that the client wants, if not at his or her fingertips, at least available within a certain time frame. Can I ask you, Mary Teresa, do you keep any kind of lists of information that you find yourself relying on time and time again?
Well, I do keep a very in-depth address and telephone book that I need more for the lawyer than for the client, with the telephone numbers of every courthouse in the province of Ontario and the clerk's offices, the Crowns, their fax numbers. I find that's very helpful for the lawyer when he yells, I need the number for such and such, or can you give me the address of such and such. I find that I need those addresses and phone numbers myself when I need to find out court dates, or when I need to call and find out what the charges are, or if I need an officer's name. I also find them important when you need to know what police station is associated with what courthouse. If a client is being arrested, then you can tell the lawyer he's been arrested at 22 Division, and therefore you know that he's going to be going to the East Mall Courthouse for his bail hearing. I don't really keep an active client list myself.
Where can people get the kind of information that you've been talking about, phone numbers for particular police divisions or courthouses or Crown Attorney's office?
Well, I don't know if it's in the telephone book anymore. It always was in the telephone book. You could find it either in the white pages or the blue pages, each and every courthouse. And I remember looking at the new blue pages, and they don't seem to have the list that they used to have. They would have the Crown, the court reporters, the Salvation Army. They always had them in the telephone book, but I don't find them so much anymore. So I have just compiled this myself over the years.
They have pared it down considerably. That used to be in the blue pages. But what I find to be a really good tool is the lawyer's phone book, that gray thing that's dog-eared and it stays on your desk. And what I do, just to make things easier, is I tab it at the point where Ontario Court of Justice, the General Division, the Provincial Division, the Crown Attorney's numbers, and I do that in my lawyer that I work for. I tab it for her, and I find that a lot of people are always grabbing mine because it's just so easy to quick reference use it and that type of thing.
Mary Teresa, you are involved in an office where there's a very heavy trial caseload. Is there anything that you as a member of the support staff do to assist the lawyer in preparing his cases for trial?
I order the informations, and once I get the informations, I find out from the lawyer if he wants disclosure ordered, and as Cathy Corrick pointed out too, it shows you the police officer's name and division, and then you can see about ordering disclosure from the Crown Attorney's office. I keep track of subpoenas that have been dropped off, and I send out the judge's orders when prisoners have to be moved from place to place. Let's say they're serving a sentence and they have a trial coming up at Old City Hall next week. First of all, I ask the lawyer if he wants the prisoner to be there, because sometimes they don't, if they're a bit too busy, or sometimes the prisoner doesn't want to be there because he's established in a program at the jail or something. So then I make sure that the judge's orders are taken to the district courthouse for bail reviews, or to the provincial courthouse to move the prisoner to the trial court. I have to give subpoenas to the sheriff. I have to keep track of when I have dropped them off with the sheriff, and make sure that they're returned in time for the trial so that we know the person has been served.
I'm going to back you up a couple of steps, Mary Teresa. Cathy Corrick spoke to you earlier about ordering informations. Maybe it would be helpful for people to know, how do you go about getting copies of informations, and how do you go about getting hold of the disclosure?
Okay. If you want to order an information, generally you can write a letter to the clerk's office. You want to give them the client's name, his date of birth if you have it, the charges that he's facing, the court date that is next coming up, whether it's a set date or whether it's a trial, the courtroom number, and you advise them that you would like to have a copy of the information, and would they send it back to you. Sometimes, because I'm out and about myself quite a bit, I pick them up myself. If I go to College Park, I just go to the clerk's office and ask for them, and then you pay for them. Or at Old City Hall, I do the same thing, pick them up myself. So once you receive the information, then you have to order disclosure, and there are different procedures for each Crown Attorney's office. The majority of them, you can fax them a form that you write down all the information that you want, the client's name, the officer's name, the division, the charges. You fax it to them and say that you'd like to have disclosure, and then they'll either call you, and you can arrange the disclosure session by looking at the lawyer's diary and saying, yes, he's going to be in Scarborough on the 22nd of May, and he can do the disclosure at 9 o'clock. Or you can pick it up yourself, which they don't generally allow anymore, but we used to be able to pick up the disclosure ourselves.
Lisa, Mary Teresa has talked about ordering the informations and ordering the disclosure. How do you keep track, especially in an office like yours where there are perhaps 3 or 4 or more lawyers? How do you keep track of where you are with any particular case and whether or not the information you ordered 2 months ago or the disclosure that you asked for 2 weeks ago has actually come in?
Well, first of all, I put a note on the diary, the duplicate diary that I keep of the lawyer I work for. I put a note on it on my desk. I also correlate that with my active client list. If there is a disclosure pending to be picked up or a meeting attended on a certain date, I put that on there for my own information. And then, of course, it's always put on the court list as well when disclosure has to be picked up. Now, something that is, I think, very important is that even though disclosure's been ordered, and the practice of a lot of courts is to set the disclosure date when you order the disclosure, I never rely upon the fact that they say it's going to be ready at a certain point in time, and then the lawyer would go there and it's not ready, because invariably it is not ready, and they don't have the files. So I try and always call beforehand to make sure that it is available, and that's generally it. I don't find it that a complicated procedure, and in fact in our office we don't usually order the information and get a copy of it. I frequently just call the clerk's office and ask them to pull the information, just to give me the division number or that type of thing, and then just order it that way. I don't go through the process of ordering information. I find that time consuming and kind of slows the whole thing down.
Some of you may have done some work on the civil side where there's a lot of emphasis put on keeping what is known as a tickler system, so that limitation periods and other important dates aren't lost in the shuffle. Are you talking, Lisa, about a form of a tickler system then in a criminal practice?
Yeah, I do it. It's kind of probably very simplistic. It's not an advanced tickler system. It's just a little yellow stick-it note I just stick on my thing that says, call here at such and such a time and make sure that disclosure is available. And I usually put it so that it's at least 2 weeks before the upcoming trial date, even though the lawyer generally doesn't look at it until sometimes the night before. It's a good idea to make sure, I think 2 weeks or so, it gives it enough time to arrange for pickup.
Let's put it this way. You can be sure that if it's not in the file, it will be the one time that the lawyer wants to look at it earlier than the night before. Mary Teresa, I noticed from your job description in the program materials that you are involved with a lot of filing of court documentation and so on. And that brings me to the next area that I wanted to talk a little bit about. Do you see a place in a criminal law practice for the use of precedents by support staff?
Oh, definitely. I have many, many precedents. Because I don't have a computer, the majority of my precedents are forms that I fill in the blank on, which the court may not appreciate, but it makes things easy for me. I use forms for transcripts, for ordering disclosure, for ordering medical authorizations. I use forms when I want to send out a charter delay argument motion, when I want to do a bail review, or when I want to have a judge's order prepared to bring a prisoner in, when the client wishes to sign a guilty plea, authorizing the lawyer to go ahead and plead guilty on his behalf, and the client knows what he's getting himself into. I use forms for traversing charges from one jurisdiction to another. I use a form for an adjournment motion. Generally, these are the precedents that I use. I keep them in files at the side of my desk in alphabetical order, so they're handy when I need them right away. Sometimes the lawyers need them as well. If they need a fax lead form, it's a form as well that's right there for them. Sometimes they try to send things out by fax. But I think precedents are very important, and I find when I'm doing something different, I definitely keep a copy of it. If I'm doing something new, I also do a lot of drug restoration money applications, so those change every once in a while. I have to keep my precedent up to date on those. Bail reviews and things like that pretty well stay the same, but
when you're dealing with something that is, as you say, new within your office and you maybe don't have a precedent or a form for it already, where do you go to get that?
Generally, I phone other legal secretaries that I know who might have one, or I try to get one from the court itself. Sometimes you can get one from, if let's say it's a restoration application, you've never done one before, you could call the Department of Justice and see if they would have one from someone else that they could send to you.
So basically, you go to other sources to see if there's something ready-made that you can perhaps use as is or adapt to the practice within your firm?
That's right. Or I can ask the lawyer if he can give me something, a form, if he can say something to me that I can take down.
We're usually the source of last resort, I think, for that kind of material. Lisa, given that your office is computerized, have you found that that's made a difference in terms of organizing and keeping precedents?
Definitely. Even though we are computerized, and I do keep a separate file, as they're called, on my computer, like we do a lot of appellate work. I have Court of Appeal precedents, and they're quite extensive. And then I have what I group into miscellaneous precedents, which encompass everything else you could possibly need. I do also keep a hard copy of it in like a binder form because it's, I think, invaluable to the lawyer, because when they're dictating something, they want to be able to look at it, and they can't look at your computer file and dictate from that. But I have quite an extensive list, and every time I do something new, I put it into template form on my computer, and then of course, so every time I want to do that document, I don't have to change the precedent that I have. I can just make a copy of it and then put in all the information, and then you don't have to go through all the process of setting up the document, the style of cause, and a lot of it really does cut down on time, because a lot of the appeal documents can be quite lengthy, and you have to do them all the time, and they can take up a lot of time.
And do you find that because these kinds of documents are on computer, that it's easier for other people in the office to have access to them if, for example, you're away on a particular day or you're tied up with something else and can't attend to a matter right away?
Well, everybody in our office has the same precedents that in template form on their computer. And I think just by the way we all organize our computers, at any time when a particular secretary is away, another secretary can get in there and do work and help out in that fashion.
So you've tried to integrate, given that there are several lawyers in your office, each with their own secretarial assistants, you've tried to organize things then so that there's a pool of information? Let me go on then, Lisa. You've mentioned documents for appellate work, and the lawyers for whom you work are well known for their practice in the Court of Appeal. What I want to ask you about is document preparation and work on appeals. Has the fact that criminal lawyers are becoming increasingly involved in appellate work made a difference in how an office needs to be organized from your point of view?
My experience is that in the trial process, I very rarely do any kind of documentation. I mean, if there's going to be a bail review or something, or if the lawyer is putting together some type of memo on the background of the offense that they would be using for sentencing, or just some information that they would have to use at trial. That's basically it. And aside from ordering disclosure, that's basically it that I do for trials. The bulk of the work that I do, because we're mostly focusing on appellate work in my office, is the appeal documentation. And every appeal, although they're essentially the same and follow the same steps and have the same documentation, they can be different in that if you have a sentence appeal or a conviction appeal, and you have to file the same documentation, and a lot of it is basically a form, and you're just changing the names, changing the dates, that type of thing. And so what I do is, instead of waiting for the lawyer to tell me, do such and such, I go ahead and do it, and I know, because I know the steps of the appeal, the appeal has to take. I just go ahead and do the documentation and do it basically up to the point of preparation of the appeal book. And then from then on, the factum and authorities are what's left for the lawyer to do, and I take away a lot of the busy work there.
We're going to be talking later this afternoon in a great deal more detail about the kinds of documents you need to prepare for the Court of Appeal and the order in which those documents need to be prepared. I think it's fair to say, Lisa, that there are some rather strict time requirements that the Court of Appeal has laid down, and there are also some rather strict requirements about the form in which documents be filed at the Court of Appeal. Have you developed any kind of checklist or way of keeping track of whether or not you've met those time requirements for each document involved in each appeal?
Well, I do keep a checklist, just basically saying the client's name and when you get the Court of Appeal number, to keep that handy, because of course that has to go on every document that you file that relates to that appeal. I then find out essentially, especially if it's a new file, if there's been a prisoner's notice of appeal file, because that would maintain there's a 30-day time limit from the point of either conviction or sentence, depending on what you're appealing, to file your notice to preserve the right to appeal. So it's essential when you get a new file to make sure that a prisoner's notice has been filed if you hadn't been retained within that 30-day period, so that they do have their right preserved. And then just to make sure that the solicitor's notice is filed and the consent, and then go on to prepare the appeal book and any other documents, just so I know at a glance just what has been filed on that case.
I think it's fair to say that if you're working in an office that is involved in doing Court of Appeal work, you'll find the kind of checklist that Lisa has described to be very, very helpful, because otherwise it is easy to overlook important time periods. And again, I think, Lisa, it really goes back to what you mentioned earlier about trying to construct a simplified kind of tickler system in the criminal field. Is that fair?
Yeah, and I also have kind of a diversified type of checklist that I use for perfecting appeals, in that whenever you have to prepare an appeal book in a case, you always have to get the exhibits from the court, and the normal procedure is to file the consent, and hopefully at that time the exhibits are there. Now, invariably they are not, and they're lost somewhere in limbo between the originating court and the Court of Appeal behind their counter in this humongous pile of documents. So it's a constant keeping track of which ones we've received, which ones are outstanding, and how you relate that to the actual progress of the appeal, because in order for the appeal to be perfected, you have to file the appeal book. So if you have the transcripts and the appeal is near perfection, and you don't have the exhibits, that can prove to be a problem. So I kind of, I guess once a week, on the phone to the Court of Appeal, trying to find out where certain ones are, and I like to keep a running list just to find out, just to keep track of which ones I've received and which ones are still owed to me.
Mary Teresa, I want to flip back now to the trial stage of things. And again, I know that you do a great deal of court appearances for the lawyers in your office in terms of setting dates and obtaining adjournments and so on. And what I'm wondering is how you effectively integrate that, and how members of the audience today who want to do more of that kind of thing in addition to the work that has to be done in the office can integrate that with all of their other responsibilities so that everything gets done.
Well, I do spend a great deal of time in court, and it's generally all morning, so I get back to the office around 11:30 or 12. And I have to decide at that time what is most important for me to get done before the end of the day. I can either look at what's sitting on my desk that the lawyer has given me from the night before, or I can quickly listen to the tapes that are there to see if anything has to be done right away. Or perhaps if the lawyer is calling me, I can say, is there anything that you need done before the end of the day? I've got to decide whether what correspondence is most important, whether transcripts have to be ordered, whether bail reviews have to be prepared. I generally leave my accounts to the clients or accounts to legal aid to the very last, and sometimes they don't get done. They're probably the most important in the lawyer's mind, but I do have to decide whether the judge's order has to be done right now, or the letter requesting medical authorization, medical information has to be done first. It's important that I sit down and take a look at what's in front of me, and then decide what has to be done first and what can be left to the last, or what can wait till tomorrow.
So in effect, you're constantly trying to set priorities in
Yes.
terms of the ongoing work in the office and given your knowledge about the client files.
That's right, and I'm sort of shuffling the files and saying, okay, this has to be done, and put this underneath, and changing the files around every day.
And you just hope that one of the lawyers doesn't call in with some demand for something on an urgent basis.
That's right.
Lisa, it seems that whenever I hand a file to my secretary and tell her, all right, this case has been completed and you can close out the file, she's no longer done that. When I'm back at her desk saying, oh, you know what, I need a piece of information back from that file I gave you to close out 2 weeks ago. What I'm wondering is, how should files be handled once the lawyer comes to you and says this work has been completed, so that you make sure that there is always easy access to the information in the file?
Well, generally when we close a file, we don't ship it off to storage right away. I like to keep it around for, I would say, a good 6 months to a year, because you know they're going to want something from it, or the client's going to be calling up, they're going to have some type of problem if they're in custody, like the situation that happens if the sentence gets screwed up in some way. Then once we ship them out, we have developed a system in our office for easy access, and what we do is, I'm sure all of you keep file cards with all the information, and when you close it, you put it on a separate Rolodex for your closed files. We put a sticker on it which tells at a glance what box it's in, so when you want a file back, it's just literally, and the lawyer can do it himself, flip it to the card, see what box it's in, and just call Tippett Richardson and get it back. We also generally, because we do a lot of appeal work, we have a lot of case law in the file at any given time, and before I close a file, we pull all the case law, and I keep an up-to-date case file arranged by topic, so that when a certain issue has to be researched again, you don't have to research from scratch. You've got something there to work with, and it's just a matter of updating it.
Could I add something to that?
Sure.
The gentleman that I work for, Mr. Gorel, does not keep filing systems such as that. Our files are filed as in alphabetical order in filing cabinets in the basement, because he believes that when he calls me and says, I need so-and-so's criminal record, all I have to do is go down and look under R. Richardson, pull out every single file, and I can quickly flip through and find the criminal record. Whereas if I've got to send away to Tippett Richardson or someplace, it's going to be difficult for him when he needs it immediately, because sometimes the Crown Attorney has an addition on the criminal record that he is sure, or his client is certain, is not supposed to be there, or there's a change in, let's say the client was convicted of theft under and the criminal record says theft over. He needs the criminal record immediately, and that's the best way for us to get a hold of it.
You're, I guess, in the fortunate position of having
Space.
the extra space to keep the files, which
Yes.
of course is a major concern in these days of high overheads. But I think the message I'm getting from both of you is that from your point of view, it's much easier to retrieve files in the future if there is some kind of organizational system in place, and if that system is followed whenever a file is closed out. Lisa, you had also mentioned to me that you do something interesting again through the use of computers.
What I do is, as I mentioned before, every time I open a file, I keep a file on the computer for that particular client, and I keep all documentation that I've prepared throughout the life of the file. When I close it, throwing out some inconsequential memos or anything like that, any kind of notes that have been done, I do keep on a floppy disk all documentation that I prepared that took any kind of length of time, important things like the reporting letter, a factum, the final account or any interim accounts, just so those things you can have at quick reference, because a lot of times they'll be wanting to find out what exactly happened in a file, or they'll be looking for a factum to use as a precedent or that type of thing. And so I have all those things just in the space of a computer disk shoved in my drawer, just in case I need them.
You've probably all had the experience where one of the lawyers you work for has said to you, please accomplish X by the end of the day, and giving you no further information about how you're supposed to get X done. It's a broad question, but Mary Teresa, when you're assigned a task or you're asked to do something and you don't immediately know how to tackle it, or maybe you don't know how ultimately to deal with the matter, where do you go to get the information you need?
Generally to other legal secretaries who may have a precedent for such a thing, or to the lawyer that you're working for, or other lawyers in the office. I don't generally go to the court or the Crown because I don't find them to be very helpful in providing me with any information. So it's usually the secretaries that I know, secretaries that are in the office, lawyers in the office, or the lawyer that I work for. Or sometimes I try and make it up myself. If it's an affidavit, you can pretty well make it up yourself. Or I had an example, in January, I had to ask for leave for time to file a drug restoration application. Usually we always get them filed in time, but because we don't do any appeal work, I didn't know how to go about wording the request for the leave. So I just made it up myself. It seemed to be okay when it got to court, so.
Lisa, do you have any other quick sources of information when you get stuck?
I do call people at the court office, and I found them to be quite helpful. And even though sometimes you sound like an idiot on the phone, it's better than messing it up in the long run. And because we do a lot of appeal work, I have a pretty good rapport with a lot of people at the Court of Appeal and have found them to be quite helpful. And if I call them and say, you know, such and such has to be done, can you give me a precedent of this, or can you tell me where I can find such a thing, they generally will steer me in the right direction.
Again, Mary Teresa, you've mentioned being able to call other secretaries or support staff, and Lisa, you've mentioned the matter of having a rapport with staff in government or court or Crown Attorney's offices. And again, you both seem to be saying perhaps the same thing in a little different way, which is that the people you get to know through your work can prove to be very important sources of assistance when you run into difficulties. Can I just ask you, Lisa, by way of follow-up, where do you draw the line between phoning somebody outside of the office and indicating you don't perhaps know the answer or know how to handle something, and when you might go back, for example, to the instructing lawyer and say, I'm sorry, I really don't understand what it is you want me to do, or I'm really not sure what direction I should be headed in?
I guess if it's a situation where you're just looking at a form and you maybe don't have an idea of how the form is supposed to be worded or something like that, in that situation I would call the court. But if it's a procedural thing and you're maybe not sure, I think on most situations it's best to ask the lawyer first, because I'm sure they have an idea of what they're asking you to do, even though maybe they're not communicating it very clearly. Another thing that I do is when the ORs come in, or when the supplements come into the code or the Ontario Annual Practice, I'll skim through them to see if there's any practice directions or anything like that, and at that point, you know, modify my precedents, because a lot of the time that stuff does come across your desk, and then really you should be kept abreast of what's happening in the field and how things are changing.
Mary Teresa, perhaps just by way of closing, you could leave us with the one thing that you found most helpful in organizing your work and keeping your lawyer's practice organized.
Well, it sounds very simple, but it's filing. Putting my files away at the end of the day, because I end up with, when I come in the morning, there's a pile about this high on the lawyer's desk that have things that need to be done to them. And then at the end of the day, I've got a pile this high that I have completed the work. And I find invariably, if I don't put the files away in the file at night, in the morning the lawyer or someone else will call me requesting information, someone's date of birth, they need the criminal record, they need something from the file, and if it's not put away, then I waste 10-15 minutes trying to find out where the file is, looking for it. I just find that's my best tool. I do that every single day, put all my files away so that I know where they are when I need them.
Lisa, what's the one thing that you found most useful?
I would say it would have to be keeping on top of things. You know, you can be the most organized person in the world, but if you can't keep on top of your work and it starts piling up, you'll just be drowning in it. And I find the best thing to do is to, as Mary Teresa mentioned, go through your stuff and learn to prioritize and learn to deal with the work and basically just plow through it systematically. I remember when I first started and I didn't have a lot of experience even as in the secretarial field. I'd come in the morning, there'd be 2 tapes on my desk, and be like, this is going to take me a week, or something like that. And instead, just to remain calm and just go through it. And a lot of the times you find that it doesn't take you half as long as you think it will. And you get it all done, and you can read your book. No, just kidding.
Well, on that note, we're going to break now until 11 o'clock for coffee and other refreshments. Arnie Schwartz is here when we resume to talk to you about dealing with legal aid and legal aid accounts, so don't go away. I want to thank both Mary, Teresa, and Lisa for their very helpful comments and suggestions.